Okay. Fleischman,
Here.
Shining,
Here.
Spyro,
Here, sorry, I was on mute.
okay, and Judge Yu.
I'm here. Good afternoon, everyone.
Hi. So we have a quorum, we're all present, and we have a number of guests as well.
Okay. I think I'm going to start off by asking for public comment.
We do have a raised hand, Leah, so I'm going to go ahead and promote to panelists so that they can speak. It's Ann Hall.
Okay, go ahead. Anne, I think you have to unmute yourself.
Great.
Okay, go ahead.
Can you see me, everybody?
Yes.
Yeah.
Hi.
Hi.
For public comment, I wanted to raise a concern that I have as a advocate of especially low-income workers. Many, many times people come to me having received bad advice from non-attorneys that result in their failure to take action concerning their case, and results in the running of the statute of limitations that would provide them the opportunity to take effective action. I'm concerned that again and again I have this experience where someone comes into my office and says that they were advised by a person at a workers' compensation hearing or a non-attorney insurance person telling them to just let things go, and they'll have plenty of time, only to come to my office to have experiences that aren't good because they are not no longer have the ability to bring the cause of action or take any kind of action by which their interests could be protected.
May I ask Anne a question?
Yes.
Well, I have to, Leah should tell me yes or no.
Yes, go ahead, Ira.
Thank you. And I appreciate the point you made. I've had that experience too. But I've also had the experience, tell me if you have, where somebody comes to me, my office, and they didn't get any advice at all from anybody, and they've blown the statute of limitations. That must have happened to you, right?
Certainly.
All right, so what I'm implying is that if they got some advice from, it might be better than none at all.
Agreed.
Ira, has that happened since the legislature extended the statutes of limitations for most employment claims?
Yes, certainly it has. The 1 year's PAGA statute of limitations has expired on many people before the legislature extended the statute of limitations.
My question was, has it happened after?
Yes, it has happened after. People come
Okay.
to me and I said yes.
Okay.
Okay. Any other?
Yes, we do have 2 more raised hands. The next one up is Melissa Johnson.
All right.
Oh, I'm sorry. I've got a request on public comment. I emailed about this, but I suggest that we have public comment during the discussions by our subgroup as opposed to before, so that the members of the public can see what the salient points are rather than address a very general subject matter. I have another request too, but this is, I'll stop there.
And I have one too as well, but we can do with Ira's.
Okay, maybe
Can I
before,
respond? And I think I prefer to hear the public comments first, Ira, because it helps me frame the issues when I listen to the people I believe are the subject matter experts.
Well, I'm sorry if I'm interrupting anybody, but my thought was we have some discussion among ourselves, meaning the panel members, and then after some minutes, we ask the public to talk, and then they talk for some minutes, and then we talk again and finish that subject.
Oh, sorry. We have subject matter experts who've been invited here. And so I'm worried that we would then not use their time well, because I have asked my colleagues on the bench to come and talk. And so generally, I assume that the subject matter experts have all been reached out to by, staff or commission members. And that means they'd have to just be on longer than perhaps they have the bandwidth for. So, and plus for me, in terms of thinking through the issues, I like to hear the public comment because it alerts me to the concerns. And then I know I can ask the subject matter expert what was raised by the public member. Whereas if the subject matter experts talk and then we talk and then the public talks, I feel like we're just gonna go back in a circle again. We'll need to go the subject matter expert.
I'm going to jump in because we do have a number of speakers today and we have limited time. Ira, I think today may not be the day to implement your recommendation because we do have all of these folks we've invited to come in and speak. I also think one of the challenges is we don't have a chair for these subcommittees. They're sort of informal, and I think we are going to need to appoint chairs and make them more formal because ultimately that would be the chair's call how public comment is handled. But if we could for today just get a listing of all of the invited speakers, I think that would be helpful because I don't know that I have all of them. I think Noah Leibowitz, Chris Knopf, Micah Star Liberty. Who else has been invited? Linda, do you have the comprehensive list of who's?
The list that I have is Chris Knopf, Noah Leibowitz, Michelle Liberty, Laura Rutherford, and DeCarol Davis.
Okay. Are there folks that are missing, Judge Yu in particular? I'm not sure we have.
I don't think we're missing anybody.
Okay, all right. So that is
That addresses my point also.
just the number of public speakers, Carolyn. I mean, the number of invited speakers, 1, 2, 3. So I think we have 5. So let's continue with a couple more public comments, and then let's go into hearing from our invited speakers. Does that work for the working group? Okay, I see next Adelaida.
No, actually it's Melissa Johnson. She's been waiting.
All right, thank you. Go ahead, Melissa.
I have. Hi, thank you for allowing me to have some time to talk. I am a plaintiff's employment lawyer. I've been practicing plaintiff's employment law for 24 years. I am on the board of directors of the California Employment Lawyers Association and here to speak on its behalf. I'm also the secretary of the San Diego County Bar Association, but not here to speak on its behalf. I wanted to address the idea that paraprofessionals may be able to engage in providing services for workplace grievances. And the reason I used my air quotes is because workplace grievances seems to be an extremely broad term and not necessarily defined as to what the scope of what that would include. Our concern is that workplace grievances could encompass protected activity such as anything that's protected under FEHA, the Fair Employment and Housing Act. It could encompass anything that is included in the Labor Code, and it could be included in state and federal whistleblower statutes and many other statutes that protect workers. It's my understanding that FEHA claims have already been tentatively excluded from this, the idea that paraprofessionals could represent employees. It's my understanding that wage and hour violations have already mostly been excluded. The problem is that if a dispute isn't protected by the law, and a lot of what's already been excluded is protected by the law, if a dispute's not necessarily protected by the law, what exactly, and there's a question, what exactly are the disputes that would be subject to the workplace disputes that a paraprofessional might help with. Also, union activity is typically designated to be handled by union representatives who also have access to union attorneys. And it's just, employment law is complicated. It's a very complicated web of varying statutes and limitations, statutes and regulations, and case law. Some of that's state law, some of that's federal law, even some of it's local law. For example, an employee might be engaged in protected activity, but when a client comes to my office and my colleague's office, or they call us, one of the things that we have to unwind is exactly what statutes are they protected under, and exactly what protections do they have. What statutes of limitations apply to each of those, because there can be different statutes of limitations for FEHA actions.
Ms. Johnson,
And some
interrupt for a minute. You've been over 3 minutes now, so I do need you to wrap up your comments.
Okay, I will. And thank you. My thought is just it's a terribly slippery slope to allow paraprofessionals to engage in representing clients when, first of all, you are dealing with such a complex area of law. Second, whatever a workplace grievance isn't necessarily defined, and you could be asking for more trouble than you're trying to solve by allowing untrained professionals to engage in this type of practice. Thank you so much.
Okay, thank you. Araya, who's next?
I have Adelaida next.
Adelaida? Okay, there you go.
I haven't done this before, so I'm learning. My question is about the same thing that was just talked about in terms of the paraprofessionals. Now, we're talking about the people that have not taken the bar exam because of the pandemic and are being given 2 years to practice under an attorney and then take the bar within those 2 years. My comment is,
Let me just interrupt you. That's not what we're talking about with this working group. There is sort of on a concurrent track a whole effort or initiative around provisional licensing related to COVID and bar exam delays. This is regarding the development of a permanent licensed paraprofessional program in California. This would not be limited to folks that are impacted currently by COVID or who haven't been able to take the bar exam.
I am. Oh, so this is for somebody who has not even taken the bar exam, who can do this type of work under the supervision of an attorney?
No, well, the specific parameters of the program will be developed by this working group. You are speaking to a subcommittee of the working group focused on employment law at this time, but the idea is there would be a licensed paraprofessional, not necessarily a person who has gone to law school, who would be authorized to perform, to provide some set of legal services, the parameters of which are being discussed and will be recommended by this working group.
I got it. Okay, so I apologize that I guess I crashed the party. I'm sorry. I apologize, but thank you very much. I'll come back when it's the right party to crash.
Okay, all right, great. Araya, is there another public?
Yes, we do have Andy Katz.
All right.
Hi, sorry, my connection disconnected. Thank you for including public comment in your proceedings. I want to associate myself with the comments of Melissa Johnson, as well as the forthcoming comments from Noah Leibowitz. I'm a member of the Consumer Attorneys of California and the California Employment Lawyers Association. Wanted to make a couple comments specific to unemployment insurance. I think the workshop reports that you've published earlier, particularly from June 30th, summarize the current status that non-lawyers are able to represent claimants before the EDD currently, and non-lawyers are able to help assist individuals fill out claim forms and provide information about how to proceed with the process. So I think it's important to consider what exactly is the problem that's trying to be solved, because the Employment Development Department already allows for assistance from non-lawyers. But there are risks if somebody has a legal claim and has the perception that they're receiving legal counsel. So the one issue that's covered fairly well in your prior written report is the evidence risk. Often unemployment insurance hearings are happening well in advance of a worker realizing that they have a retaliation lawsuit or a FEHA claim that they should bring. And the evidence that they could testify to during an unemployment insurance hearing could implicate some of their rights in other statutory matters, and they might need counsel regarding those rights. So I think it would be important to be very careful about having any kind of professional licensure related to unemployment insurance. But we do need our legal aid and university clinics to be assisting people with that, often with a frontline worker being a non-lawyer under the supervision of an attorney. So we absolutely do need a division of labor for helping people with unemployment insurance, but there's so many complex issues in the employment field that we need the primary bulk of these services to be delivered under the supervision of an attorney, primarily through nonprofit legal aid services. Lastly, I would say that there are risks to not having some kind of supervision in this area because of matters that would be outside the scope of a paraprofessional. Thank you.
Thank you. Araya, any additional?
We have one more is Brennan Kahn. I'm going to go ahead and come in. Brennan Kahn.
Yes, I think I'm here. Okay, hi.
Right.
Good afternoon, everyone. What I wanted to address was something the prior speaker brought up, and I think it's a very important point, which is the overlap between various legal claims and rights and other legal claims and rights. And there's let's call it a trap that can be easily fallen into here with any non-attorney giving advice about almost any employment matter, because of the overlap between the various claims that often arise in employment cases. An example I can have is just recently this last week, I got into a discovery dispute with an opposing counsel regarding what documents were relevant to what different claims. And the defendant wanted something much more specific from me, which is understandable. But my argument was that, and this is a disability case, for example, that the documents that would relate to job duties, or documents that relate to reasonable accommodations, or documents that would relate to complaints, there's every element of every claim and allegation I make in a typical wrongful termination, disability, discrimination case relates to each other. And so if you were to parse out, for example, a reasonable accommodation analysis from a wrongful termination analysis, there is no logistical or efficient way to do that that would not harm one or the other if you did not tie them together. So if you were to say that there's any one element that a non-attorney could help a layman or a potential client address without getting into other areas of the law that would naturally implicate or affect, could be not only, in my view, potentially malpractice if that person was licensed, but could also affect a legitimate claim they have. So the problem arises that if there's going to be any carve-outs, I'm not sure how you can really do that without basically affecting legitimate claims these people may have. And I think that's something that has to be considered very, very, very carefully. Thank you.
Thank you. All right.
We don't have any more raised hands from the attendees, but we do have, or we had a raised hand from a panelist, but no longer.
Okay, great. And I did want to make sure to point out that the California Employment Lawyers Association also did submit written public comment, which Linda circulated to all of you and will be posted to the Dropbox. So we have, my understanding is we have 5 speakers. Judge, I want to confirm that we don't actually have any judicial speakers. Is that correct?
That's correct. I wasn't aware that anyone asked me to look for that. So
No, we didn't. I think I misheard you earlier.
Oh,
I just
okay.
wanted to make sure.
So
So
I meant in the past I had asked judges, but not this time.
okay, so if we could first have the speakers just say your name and introduce yourself, what organization you're with. And then I'd like to hear from subcommittee members if you would like to hear from everybody all at once, or you want to go sequentially speaker to speaker. But I see first up DeCarol Davis. So if you could just say what organization you're with, that would be very helpful.
Hi, I am an attorney with Legal Aid at Work. I work in the Community Legal Services program and help with Mike Gately to run our workers' rights clinics throughout the state of California.
Okay, great, thank you. Laura Rutherford.
Hi, my name is Laura Rutherford. I head up the labor and employment practice at Lathrop GPM here in Los Angeles, and I was invited by Steve Fleischman to speak on behalf of the employment defense lawyers.
Okay. Noah Leibowitz.
Good afternoon. This is Noah Leibowitz. I apologize, my video is not working today, so you just get audio. I am the founder of the Law Office of Noah D. Leibowitz, which is a solo practice in Berkeley. I am a former member of the executive board of the California Employment Lawyers Association and currently the chair of the CELA Fair Employment and Housing Council Regulations Committee. I'm here to speak about reasonable accommodation and disability law.
All right, Chris Knopf. Chris? I see Chris here in the participant list, but I don't. Okay. Oh, Chris, there you are. You're on mute.
Hi, sorry, I don't know what happened. I was all squared away and then it went away, but I apologize for that. I'm Christopher Knopf. I'm Director of Litigation with the Disability Rights Legal Center in Los Angeles. And I was asked to speak and provide sort of the disability community view of this particular issue. I'm also on the board of directors of an independent living center here in Los Angeles. And I'm happy to share my thoughts and answer any questions.
Okay, great. And then I think, Carolyn, you mentioned Micah Star Liberty. I don't see her. Is she?
Yeah. She's only able to come later in the meeting, so it she may not have time. We have a lot of parties, so maybe she can come another time, but she would join much later, and we'll see what other.
Okay, great. So in terms. Yes.
Sorry, you had asked, should we have everybody talk at once or do it sequentially? For me, I'm taking notes. So for someone taking notes, it might be better to hear from one person at a time.
Okay. All right. So why don't we start with DeCarol? And am I pronouncing your name correctly?
Yes.
Okay. Great. And I am actually trying to get back to the Zoom so I can do a quick screen share. I just have one slide I wanted to put up for everybody, just the focus for our subject matter experts today, denial of accommodations and inadequate resolution of workplace grievances. These were the 2 outstanding employment law topics from our last meeting of our subcommittee. Just wanted to put that up on the screen, and that hopefully today, although I'm not thinking this is entirely likely, the subcommittee will make a decision regarding those 2 outstanding topics. So DeCarol, please go ahead and give us your thoughts. paraprofessionals doing any aspects of work in these areas?
First off, I think paraprofessionals are incredible and should be empowered as much as possible, given direct supervision. I think it was Andy who had mentioned the importance of that. I personally work with law students and not paraprofessionals, paralegals, sometimes legal assistants, but it is very, very, very important that we as attorneys have direct client contact while we're doing the supervision, and that we're very clear with the client that these are law students under the supervision. I think that consent piece often resolves a lot of issues. So if you're talking to a client who knows, okay, this is someone in the legal community, a paraprofessional, and sometimes more connected to the community, as long as they know that there is direct supervision. In the hearing situation, we love that students are able to participate, and from a training standpoint, even talking with friends up at JFK at the paralegal school, it being really important to have that experiential learning. Do you want me to talk about anything? Are there any questions I can answer?
Well, I want to, before I turn it over to the group, I want to clarify that the type of program that's being contemplated here, I don't know if you're familiar with the Triple LT program in Washington, is the oldest program in the country, but this is a licensed legal paraprofessional who would not be required to work under the supervision of an attorney. So it's not the same as paralegal model or law student model. And so it's really trying to figure out what are the appropriate areas for that kind of scenario. So with that, I'll turn it over to the group. See if there's any questions for you.
Well, I do. I'm not revealing any secrets here when I say that. Well, here, I'll just ask the question. DeCarol, what would you think about paraprofessionals not working under the supervision of a lawyer, but having training in employment and working with clients on matters that are small enough dollar-wise, that a lawyer would not take them on, and they can't, there isn't enough capacity in the various nonprofits and clinics to accommodate them. And I think there isn't enough capacity for all the people who need help. What would you think of that, paraprofessional doing that without lawyer supervision?
I like it. I like it. Without knowing more about the training, right, and the complexity of the legal principles that would be applied to any of these given things, I like it. I like empowering paraprofessionals to do that work, provided consent with the client. But yeah, a lot of it's going to pertain to the training and the subject matter.
Is it okay if I just jump in? I have a question for Ms. Davis.
Yes.
So Ms. Davis, thanks so much for being here and all the work that you're doing. It's really good to meet you. And I really wanted to have somebody from your, expertise represented here. So my question is, assuming that if the State Bar decides to start a paraprofessional program, there will be some standards for conduct, there'll be some training, there'll be some accountability. If that's the case, are there any specific tasks or areas among the denial of accommodations or inadequate resolution of workplace grievances where you think it would be a good fit for a paraprofessional as opposed to an attorney where maybe it would just really require an attorney to be there? And I ask that because what we've done in our other work is really try to identify areas where paraprofessionals could be helpful and to bridge that justice gap, because it sounds like there's just, I mean, of course it would be best to have an attorney, somebody well-trained and experienced, but if that's not possible, where would paraprofessionals fit in the best? If you can think about certain areas or tasks or claims or something like that.
I think someone said front end. I can definitely see in the research, preparation, recognizing the systems that a paraprofessional would be exceptional. When I think of, I'll defer to Noah on the denial of accommodation piece, but in terms of the grievance process, one thing that we observe when there's a lack of representation or, you know, lack of duty of representation, it's that people aren't following the procedures, or someone doesn't know, or someone's not documenting something, workers aren't documenting something, and having an archive, having the procedures known, there needs to be someone who knows the entire procedure, the whole CBA, even with a company and how they approach their interactive process, who knows the procedure and who's able to launch and initiate and carry that throughout the whole process. I know that's very broad, but that's a tough question. Yeah, it's a good question though. No. Are there any follow-ups that would kind of refine my response?
Maybe we'll get there as we move to hear from some other speakers. So why don't we move, I'm just looking on my screen, Laura Rutherford.
Hi, everybody. Thank you so much for having me speak today, and I really do appreciate the opportunity. So as I mentioned, I'm a management side employment lawyer, and I head up the L&E practice at Lathrop GPM in Los Angeles. I've been doing employment law for about 14 years now on the defense side, and frequently counsel employers on issues related to the interactive process and the reasonable accommodation. My position here is that I really, while I'm all for empowering anyone to do anything, I do think that there has to be limits on what we're empowering them to do. And California employment law, it's no secret, you know, these are very complex laws. I know another speaker raised this earlier, or at least a public appearance designee. And you know, there's a lot of interrelationships between the laws. It's not to suggest that people can't figure it out. They can, but what I'm trying to say here is that when I advise clients, and I would assume that when plaintiffs' lawyers are advising their clients, the advice is given in the context of litigation. So frequently I'm asked, what do we do in this situation? We want to make sure not only that we accommodate someone, but that we don't step on a law that triggers a lawsuit later on. And given that I'm licensed to appear before the courts, I am able to infuse my advice with a litigation perspective, which is the primary goal for most, or if not all of my clients, is to avoid litigation. That's why they pick up the phone. I think that when employees might seek advice, yes, they want advice on what to do and handle with their employer, but those issues should and can be worked out with their employer. I don't think that they need a paraprofessional to guide them on how to interact with their employer. That's what the employer is there for. And of course, we're encouraging our clients to dialogue with the employees, because that's the whole purpose of the interactive process. So, you know, with that backdrop in mind, I would just add that the legal profession as a whole, right, is based on the fact that lawyers are held to a higher standard. We're held to have had a training, our 3 years of law school. We've been licensed, we've studied and taken the bar exam, but we're practicing law in the regular day-to-day course of our business. So that when people call us, they know that they've got a trusted, experienced advisor on the phone. And part of that experience, as I mentioned, is litigation, which I think is just a key component to this piece of the puzzle. And so, you know, in general, I think there might be areas of the law where paraprofessionals can assist, but I do not think that California employment law nor federal employment law are those areas.
Yes, Judge Yu.
Thank you so much, Ms. Rutherford. Am I saying that right?
You are, yes.
Okay, thank you. Thank you so much for being here. I had a question, and I was wondering, have you ever had the experience where an employee, the employer is willing to engage in the dialogue that you mentioned, and the employee is feeling either daunted or intimidated because maybe there's a sense that there's not as much power, or there's some language issues or other access issues where the employee would possibly benefit from the assistance of a paraprofessional?
So the answer to your question is sure, right? We always have situations where employers, and I mean, the answer to the first part of your question, right? The second is, do I think a paraprofessional can assist? So the first is, do those problems exist? Of course, they certainly do. And, you know, if an employer were to call me and explain that to me, I would say, call the employee and talk them through it, right? I mean, my true belief, being a management side employment lawyer, is that there's not enough direct communication between employees and employers to resolve these issues. A lot, and I'm not saying anyone's at fault for that, right? It could be, as you've suggested, a language barrier. It could be a fear, intimidation error. But interjecting another person into the equation, I don't think helps the situation. I think it hurts the situation. The idea is that the employer and the employee work together to resolve all of their issues and differences. So let's talk about two major disputes that arise. You didn't pay me everything you were supposed to pay me, or I need help getting through this workplace issue I have, disability, sexual harassment, race, whatever, right? That's more of a non-wage and hour type of issue. You could always interpose a mediator in there to assist. And I use that term mediator loosely. Someone who could help the employee work through the issue. Depending on the size of the company, maybe there's another HR person there to assist. I can tell you that when my clients call me, they're not having me show up in the room to be their advocate against this employee, right? They're calling me to say, hey, how can we resolve this issue? Because the employee brought it to my attention. I'm not sure a paraprofessional or anyone else is going to be able to assist in that situation because we're just bridging the gap of a dialogue. I don't even know if they need to be a paraprofessional. You could bring another employee in the room, a supervisor in the room, a union representative, whoever. So I'm not sure the title paraprofessional really helps solve that problem, in my opinion.
Okay.
But I appreciate the question.
Thank you.
I have a question, if I may.
Yeah, go ahead, Ira.
Laura, I see your point. It occurs to me that paraprofessionals could be useful advising the employee. For instance, am I right that normally an employer will have the people in the HR department to consult with, outside counsel to consult with, possibly in-house counsel to consult with, whereas an employee, not in a union, which is the great majority of them, has nobody to consult with, and a paraprofessional right now could not do that because it would be practicing law to give advice on this legal problem, if it's, say, non-payment of wages, and it would help the employee. Do you agree with that, or do you think it's wrong?
I think it's wrong, and I guess my first reaction is, why couldn't you do it? Why couldn't the employee call any plaintiff's lawyer in the city and pose the question that they have? Because
Plaintiff's lawyers charge money. I don't anymore, but I'm 70 years old and I've been practicing a long time. But it's very expensive to get the advice of a lawyer, and it would be less expensive to get, and possibly free, to get the advice of a paraprofessional.
So I guess I have two responses to that. So I do think that there might be pro bono opportunities. I think someone mentioned that, but I do think that the paraprofessionals, they seem to be, that this would be an opportunity for them to charge, right? It might be less than what you might charge. And so the sort of adage of you get what you pay for might apply to that. But I think that the bigger concern here, if I was, again, I'm a management side lawyer, but if I were, representing an employee, I might think to myself, when I'm talking to this person, the paraprofessional, what experience and background am I really getting that's going to help me, and can I trust it? So I sort of mentioned earlier, right, we're held to higher standards as lawyers, and if that pool is, I don't want to use the word diluted, but if we're putting more people in that pool that don't have licenses, that don't have the same level of experience as you and I know you are by reputation, so I know the kind of experience you have, I think it can call the whole profession into disrepute. I mean, we are held to a standard of giving advice based on the experience in the industry standard. And I think that allowing people to provide advice who are not litigators, who do not practice in this space on a daily basis, is very dangerous, especially in the area of employment law. There might be simpler areas, and I said that earlier, but California employment law is incredibly complicated. And I say this moving from a litigation background. I litigated for 6 years. I was doing constitutional law, which was kind of complicated. Then I moved into California employment law. It took me like 2 or 3 years to really figure that out. But to really give the kind of advice that these people deserve, I think it should be provided by people who are held to our standards and people who practice in this space and litigate in the space daily.
Okay. Stephen, I think you've had your hand up, and then I want to move on to the next speaker. Okay, go ahead.
Just by way of background, I invited Laura because I wanted to give the group sort of a broader perspective than just hearing from employee side people. My question for Laura is, representing employers, one of the goals of this committee is to close the so-called justice gap. Am I correct in assuming that you see all kinds of small cases or small issues come across your desk, so that the idea that employees don't know their rights or don't have access to counsel may be not as great as we think? I mean, I'm just curious what your reaction is to that.
Right. Yeah, no, that's a fair question. I've never really heard of that before in this business. And my impression is that there are a lot of plaintiffs' lawyers out there, and there's new plaintiffs' lawyers in the employment space every day. So I've had one pro per case where in my 14 years who was a vexatious litigant. Other than that, everybody's been represented. And whether the case is small, meritless, or worth millions of dollars, I've never observed a situation where an employee was underrepresented in the employment law area. I think it's pretty saturated, in my opinion.
If I may, I'm not interrupting anybody.
No, go ahead, Ira.
Laura, the cases that you don't see, that are not filed, there may be many employees, don't you agree? There may be many employees who weren't able to get a lawyer, and therefore the ones who are the ones you see in litigation. The ones who aren't are the ones you don't see, so you don't know about them.
Well, obviously, I have no idea how who's out there not getting lawyers. I'd like to think my impression is that the lawyers that are filing the cases are discriminating. I mean, in a positive way. They're being, diligent and doing the investigation, and they're only filing cases that have merit. But it seems that the issue posed here today is in the employment space with respect to reasonable accommodation and the interactive process, whether or not paraprofessionals should exist, because there's no access to people to provide them with that advice. I disagree. I have litigated hundreds of cases, and I am aware of these lawyers out there promoting themselves on websites, emailing employees with various types of promotional materials. Some of them are on billboards. There are plenty of plaintiffs' lawyers out there to help the average person. And my personal belief is that a lot of these lawyers are not charging. You can see the 1-800 numbers on these websites. Call if you have any questions. You know,
I need to jump in for a second.
Yeah.
As someone who represents thousands of people a year who don't find attorneys, in this glut of plaintiff side attorneys who many of them are predatory. Many of them are not competent to practice just because they passed an exam. I would say that the power differential between workers and employers in direct contact is huge. And when I talk to my workers who are represented by either a student, legal staff, the power of having someone there alone, that power of having someone there, someone who's checking what you're saying, the empathy, the organization, knowing the system, and knowing the statute of limitations, knowing the barriers to entry. Those things are not things that employees are getting in direct communications with employers. And the intimidation factor is huge. This is someone who pays you, who sets your hours, who controls your workflow, where you may have already experienced some sort of a retaliation in the workplace. This is not lay representation. Lay representation has been studied at length and shown to empower workers to assert claims and address claims at the lowest level possible. We agree, we don't want litigation. The client doesn't want litigation. A paraprofessional can help us to de-escalate, to understand where the issues are. And in terms of accommodation, we are often referring clients to Job Accommodation Network or someone because they don't even know what accommodations they need sometimes. They really don't. And so a paraprofessional that's working in the industry, that's trained in that area, is also able to say, okay, these are the types of accommodations that we see, and would help the employer have a sophisticated conversation around those accommodations.
I'm going to jump. I'm sorry, Laura. We've got
Can I just respond to one thing? Because it's a little pertinent. As Ms. Davis said, okay, I'm sorry. Yeah, she said, you know, the only thing that stands between the paraprofessional and the professional is an exam. I don't understand that. If these people want to be lawyers, why don't they just take the exam?
Okay. All right. So, Chris Knopf, can we hear from you?
Hi, everybody. I appreciate the discussion. I've been trying to follow it exactly. But just by way of background, I'm a litigation director at Disability Rights Legal Center in Los Angeles. Been practicing for nearly 25 years on behalf of people with disabilities. Started off with Beth Zedek, and then have been really doing disability rights for most of my career. I was in private practice for 14 years. I did some employment law. I do a lot of education law, which is quite analogous actually. But my frame of reference comes from representing people with disabilities. I'm on the board of an independent living center, which, in case you don't know what that is, it's a state and federally funded office to promote the rights and the independent living of folks with disabilities throughout the state, throughout the nation. So I very much appreciate the idea of wanting to increase access to justice. Obviously very much on board with that. It's a question of how. I do agree with the speakers that I do have a lot of concern about paraprofessionals wading into this field without adequate training, experience, licensing, testing, and so forth. In my mind, there's so many specifics to know, not only about employment law, but also about disabilities and disability rights in general. You know, under state law, there's a certified access specialist system, which are folks that are trained and licensed by the state to be able to go out and do physical access inspections. And it's a very rigorous training and exam process to be able to do that. If we were to go down this road, you know, something along those lines would absolutely have to be part of it. Disabilities are wide-ranging and complex. Every person's different. Their needs are different. And my reaction is I'm really concerned to turn over to paraprofessionals that role that both attorneys as well as disability trained providers are also providing. In my view, you know, the initial solution is to empower those that are existing to assist this population, whether it's through the independent living centers or through legal aid offices that are specifically opened up and designed to do this. That's where, you know, additional capacity for access to justice can occur. So, you know, in that sense, in my experience, it's very similar to the concerns expressed earlier in the education context versus the employment context. If the right advice is not provided up front, it can, you know, destroy a case going forward. There are a variety of accommodations that have to be known about and discussed. And, you know, slip-ups can, you know, hurt the rights of the person seeking assistance. So I do share that concern as well. So, you know, I'm happy to take your questions. That's kind of my initial take on this issue. While I appreciate the focus on access, the specifics, the details, the experience and knowledge necessary in this realm, to me, really speak of a much more robust system, you know, than opening this up and requiring a little bit of training and so forth. So those are my thoughts.
I just have a question, and thank you so much, Mr. Knopf, for being here. It's about just mindful of the justice gap. I know Mr. Fleischman said the so-called justice gap, but I think it was identified that there is a justice gap. So is there any task or area in your area of expertise for practice that might be something that could be handled by a paraprofessional to address the justice gap?
Well, I think what other speakers have said, where it's under the guidance of attorneys, that's certainly a different animal in my mind. Allowing kind of the economy of paraprofessionals to open up the disability accommodations is of great concern. So proper supervision in that regard, again, proper training and licensing. In the education realm, we do have educational consultants who are generally, you know, decades experienced special education professionals, whether from school districts or teachers or parents and so forth. But those are folks that do help people without a law license, but their level of training and experience is incredible. And it's at that sort of level that I feel we would also need in the employment context.
Okay, and they're probably not giving legal advice. I'm assuming that as their educational advocates, they're really well versed in the educational system and they can advocate at IEPs or other places, but they're probably not giving legal advice. Is that right? Or
I mean, it's sort of quasi, right? They're not obviously not supposed to give legal advice, but they're very well aware of the laws under special ed to be able to assist a parent to go through the process. And it is akin to what you're looking at. But again, it is stopping short of legal advice. Absolutely.
Okay, thank you.
Any else, Ira?
Yes, that just brought an idea to my head. Chris, what if those, what do you call the people who do that kind of consulting?
Well, in the educational context, they're educational consultants.
All right, and there's similar ones in the disability field?
Well, in the disability field, it's a little bit different. It's more broad based on disabilities in general. They're independent living centers, and they're all throughout the state. There's a whole network. There's a state, you know, group that represents them and so forth. And so, you know, that could be an avenue again to, in concert with the state bar or with state bar funded legal services providers, that could potentially be a viable model down the line. But it absolutely requires that level of attorney supervision. I mean, I feel strongly in that regard because ed consultants absolutely support the concerns that are being expressed today. Ed consultants can really get families in trouble, and until they get to an attorney to look at the case and apply the law, you know, they can be helpful, but they can all be very, very hurtful.
what would you think if the ed consultants could give legal advice as a paraprofessional if they got training on the law in education, well, in education in this situation?
In my mind, Mr. Spiro, it would have to be under supervision of an attorney. I would be loath to recommend anything beyond that.
Okay, just doing a quick time check. It's almost 1 o'clock. We have not heard from Noah. I'm not sure, Carolyn, if Micah has joined us. It's a little hard for me to scroll through.
I don't see Micah, Leah.
Okay, do our members have?
I texted Micah and told her there wasn't going to be time for her, so we'll.
Okay. So do our members have time to stay and hear from Noah? Ira, I see Judge Yu nodding her head. Carolyn, Stephen, could stay a couple more minutes.
Yeah, I put my afternoon cases at 2 o'clock.
Okay.
I'm available for about 15 minutes.
Okay, so Noah. I didn't ask if you were available to stay past.
No, I'm here. Thank you.
Okay.
I have some quick, hopefully prepared remarks, and then I'm happy to answer any questions and engage in the discussion. First of all, I will say that I fully endorse Chris's notion and comments about the continued supervision of attorneys, if any paraprofessional I don't want to say access is the wrong word, but any certification is eventually approved that anything would have to be under attorney supervision. But what I'll say is this, so a little background for myself. So for the past 20 plus years, I've exclusively represented workers in employment cases, focusing on the area of disability discrimination. I've also been deeply involved in the development of legislation and regulations in this area. I was part of the group working on the POP Inc. Act, the overhaul of FEHA's disability discrimination provisions in 2000. I spearheaded CELA's review and public comment for the Fair Employment and Housing Commission when it engaged in its major overhaul and update of its disability discrimination regulations. I worked with Legal Aid at Work's Disability Workers' Rights Clinic from its inception over a decade ago. And I have organized and presented dozens of MCLE programs on the topic of disability discrimination in the workplace. So in addition to my active litigation practice, a steady part of my practice for my entire career as an attorney has been providing advice and counsel to individual employees who find themselves in need of accommodation in the workplace, helping them navigate the interactive process, ensuring they understand their rights and obligations in that process. And what I'd like to say here today is that I think opening the field of disability discrimination or denial of reasonable accommodation to non-lawyers presents some serious risks to the public. This is a highly complex area of law where individual employees require highly competent and knowledgeable counsel. It requires the ability to absorb and apply multiple statutes, stacks of regulations, agency interpretive manuals and guidance memos, and rapidly evolving case law from state and federal sources. Most importantly to today's discussion is the breadth of knowledge that is required, because an employee's interests are not always limited just to reasonable accommodation in these situations. Often other rights are implicated during the process. The employee may have rights under the Federal Family Medical Leave Act or the State California Family Rights Act. The employee may have rights under pregnancy accommodation or disability leave laws. There may be workers' compensation issues. There are also almost always medical privacy rights issues that the employee needs to understand and be able to navigate, how much medical information they must provide during the process and how much integrity they can maintain in their medical privacy. These are all crucial questions that I work through with my clients. It requires fluency in these overlapping areas beyond reasonable accommodation and a breadth of subject matter expertise that spans into several other areas of employment law. The decisions an employee makes in this process are critical to whether or not they're able to maintain their employment, and if not, ensuring that their maximum rights and remedies remain available to them. I understand the state bar in general's main focus is the protection of the members of the public. And the decision a person with a disability makes during the interactive process have the potential to impact many overlapping rights. Opening this area to non-lawyers is loaded with potential risks to members of the public. Alternatively, what I would suggest is that it is likely beyond the scope, I imagine, of this working group. But in my opinion, the focus should really be in this area that I do agree there is a justice gap and there is an access gap to good counsel. But I think the answer is not opening up the area to paraprofessionals, but to focus on more fully funding legal aid, legal services, and attorneys or workers' rights clinics in that type of public service. So that's the end of my prepared remarks. I'm happy to answer any questions.
I have one, Noah.
Yes.
Could you discuss more the medical issues when it comes to reasonable accommodations?
Sure. So when you, for instance, if you look at the regulations, the California regulations as promulgated by what was then the Fair Employment and Housing Commission, there is a notion of reasonable medical information that an employee is required in the interactive process to disclose reasonable medical information. Well, what does that mean? It's a question that's an open question, but we do know that under California state law, for instance, an employee does not have to reveal their diagnosis of their disability or their medical condition in this process. Federal law is actually different. Federal law, an employer can require an employee to disclose that information. And what we see oftentimes is out-of-state employers or employers that have HR departments that are based outside of California don't understand this difference and press employees to reveal much more medical information than they're required under state law. So these are the types of issues that come out. You know, doctor's note requests for doctor's notes. We still see employers in California requesting employees sign complete releases of their medical files and medical information as part of the interactive process, filling out forms that are over-inclusive as far as their medical information. So these are the types of things we see pretty regularly still.
And just one follow-up, is there any legislation pending in Sacramento right now to talk about these issues? I know there's like you said, there's a lot of things that happen all the time.
Not specifically on those issues. I think the regulations sought to really narrow the available scope of whatever access is required. Obviously, an employee has an obligation to provide some medical information, and it's reasonable medical documentation to support the existence of the disability and also to support the request for accommodation, whatever they may be. And so hopefully the regulations cover that. It's just a matter of compliance.
Stephen, I think you had your hand up.
Yes. My understanding is that for most of these claims, there are statutory attorney's fees recoverable, which give plaintiff attorneys economic incentive to take these cases. In light of that, can you tell us how many, what % of clients that come to you with viable claims do you turn down? And if you turn them down, are you able to refer them to friends, colleagues, or some sort of network so that they can get another opinion?
That's a difficult question. Because there's two different things. Understand that most of these situations that I'm talking about right now are certainly pre-litigation, in the sense of these are folks coming to me asking for help during the process. The goal is to maintain the employment. The goal is not to set up litigation. The goal is not to start litigation. The goal is to actually achieve the reasonable accommodation and maintain the employment. It's when those situations fail that we then switch to potentially looking at litigation. And my overall point is that the decisions that are made during this process, if the process fails, will have significant and multi-layered impacts on any potential litigation that follows. And so that's where the complexity comes in. As far as your question about, are there referral networks? Absolutely. Do we, if we can't take a case because of any number of reasons, certainly there are numbers of folks around who we can refer to. But it goes through the same kind of vetting process as any case.
So I just want to ask folks that see the answer as expanding legal aid services and clinic services. In California, with our state IOLTA programs, those services are limited, state-funded programs, those services are limited to people at 125% of poverty or below. The federal limit is 200% of poverty and below. What we saw in the California Justice Gap study was that the Justice Gap does extend way up the income ladder from that level. Folks who are not going to qualify for free legal services. We did see employment as one of the top 3 legal needs, unmet civil legal needs in the state. So I'm just curious if do you think there is a population of people who are not going to qualify for free legal services, or how would you propose that those needs be addressed? Not going to qualify for expanded legal aid unless the income cap is raised quite significantly.
Oh, before Noah answers that, Leah, I was looking into the California Justice Gap study. I could not find that data with regard to people over the 125% of poverty, which I think goes to 4%. I'm sorry, 4 times 120%. So I would like, in between the next meeting, maybe you and I and Linda can talk about where that data is. I saw it for low income, but I did not see it, as you just said, for the middle income people. But with that, just know if Mr. Leibovitz can answer.
Sure. I don't know how much insight I can provide to that. I don't really have enough. I don't feel like I have enough specific background in that data or that type of information. What I would say is that my focus is on, while obviously I agree there is a justice gap. There has been for many, many years. This is something that I've read in various publications and studies over the years. I'm just not familiar enough with the foundational data to be able to answer that specific question. What I would say, though, is that focusing on, again, the risks to the public and risks to the general public, having folks advise employees in these situations, and the folks providing the advice not having the breadth and depth of information or of practice level knowledge of these other areas of law that will be impacted and that are impacted on a regular basis by these types of considerations, puts those individual employees at risk.
Does any other member of the working group have a question, comment?
I have a question, but it's for Ms. Davis. Is it all right to leave Mr. Leibovitz?
Sure.
Okay, so based on what I'm hearing, I think I'm satisfied that there maybe isn't a fit for paraprofessionals in denial of accommodations, but I do, what Ms. Davis said resonated with me, that there is a power dynamic that's not balanced with an employee that would have to speak to some employers, that there could be other barriers like language or intimidation or past relationship dynamics that make it useful for the employee to have someone with them in a conversation about grievances. I also think there might be blind spots that employers employ or their attorneys may have coming from majority or white privilege. So I am wondering if a paraprofessional is, if there's some type of certification or regulation process where paraprofessionals could accompany employees, would that cause any problems in the future if there is litigation? Because I know the goal is to avoid litigation, but let's say the conversations don't work and they go south and now there's a lawsuit. could it be possible that the paraprofessionals' involvement might prejudice the lawsuit in the future?
I think so. I mean, I think that it would add to the argument that this person had a sophisticated party present, and they wouldn't have a strong argument for not understanding the contract or not understanding what was going on. And I think that's to the employer's advantage, again, to have someone sophisticated in the room, not to say that a worker is unsophisticated, but you have to understand the world that I work in. I'm working with very, very, very poor people.
Yes.
And to distinguish that type of service, those types of direct services from litigation, I think that's very important. I am not saying that paraprofessionals should be going into the industry and making claims, suing, things like that. I'm thinking again on the front end of supports for workers. I think another thing that's implicated in having paraprofessionals presence is confidentiality. What types of confidentiality and what modes of honor we're expecting from paraprofessionals? I think for me in the conversation, it's not knowing enough about where exactly the proposal is in terms of inserting paraprofessionals into the legal world, because I think I'm hearing all of us agree that there's a level of knowledge that you're not going to get without a lot of training, whether that's reading for law and being under the supervision of a firm or some other organization, or going to law school and doing the credentialing, because I think that's important. In the grievance process, I could see someone who is not in the organization and doesn't have, we'll say, the organizational cultural competency. That could also implicate things in terms of how a paraprofessional jumping in is interpreting the contracts and the past negotiations and that employee. I do stand by this aspect really from experience of just how powerful it is to have someone there who language is huge. And I'm not just talking about English. I'm talking about like law. I'm talking about I'm working with hundreds of unemployment insurance applicants. People are having trouble understanding this simple process. Berman hearings, wage claims, wage settlement conferences, even people negotiating on their behalf and being so emotional, like having a disability, even disclosing that, how to have a conversation around that, and having someone who's out of it being able to have more composed conversations around it. So again, this is more front end stuff. This is information that is more concrete, doesn't require as much legal analysis. It's knowing the checklists, it's knowing the numbers, it's knowing the dates, it's knowing the organizations to refer to, and those baseline things, although it's not in some contexts legal analysis, it's information that people don't have access to. And anyway, I'm rambling.
Oh, no, it's helpful, but I guess what I'm trying to decide is it definitely seems like there's a place where people need the help on the front end issues. But if the help on the front end issues, because not everything will resolve, if the help on the front end issues will make it worse for people on the back end, I'm not sure it's helpful for us to have someone on the front end. And maybe it's better for that help to happen through an attorney, even though the attorneys are scarce and harder to achieve. So that's why I'm trying to, for myself, figure out how should I exercise my one single vote on whether this goes further in the discussion, not that it's, automatically in. And I'm just trying to figure out what would be best for the people who have the gap and who need the help.
Totally. Carol, I'm sorry, but I know Stephen needs to hop off and I want to be mindful of the time. Our next meeting is on the 11th, I believe. So very quickly, I think it would be helpful to hear from the group what you want to do on the 11th. I'm thinking that we're not, certainly not at this time, ready to take votes on these issues. do you want to invite back other speakers? Do you want to really dig into this pre-litigation matter? Is there any space where having support would be helpful? So quickly hear from our subcommittee members.
I'm ready to vote.
Okay.
I'd like to start funneling again next time.
Well,
I mean, we've spent a lot of time on these subjects already.
Okay. Judge, you for the next meeting, what would you like?
Well, I didn't get an answer, so, and not that it's anybody's fault because we're running out of time, but I'm not sure if Ms. Davis could come back at the next meeting, but I'd like to just get a little bit more understanding.
On the potential harms if there was a paraprofessional support provided on the front end.
Yes.
Okay. Carolyn?
Trying to give you all the information. I do actually think front end support may outweigh the disadvantages. But you specifically asked about the disadvantages. I want to try to be objective.
Carolyn, I think for the next meeting, are there additional speakers you want to invite?
Frankly, I'm ready to vote like Stephen is, but I do have 2 more people to come in I know I have one person. I need to check on the date. I know Micah wanted to potentially come, and I had another person to specifically talk about labor grievances. So, but I'm ready to vote. You guys know my position on these 2.
Okay. Ira?
Yes. I think I want more. I would like to see more discussion, information, I should say, from others, from experts about the pre-litigation situation, and I also think that the issue is not being phrased correctly sometimes. It's phrased as what are the potential harms from a paraprofessional working for a client? But that's not the issue. The issue is what are the potential harms from that compared to the person not getting any advice at all? And the secondary question there is how prevalent is the situation where a person cannot get any advice at all? For instance, in the interactive process it is of trying to get some accommodation.
But Ira, the question is, what do you want to do next week?
That's what I said. I said what I want to do next week is get more information on the pre-litigation situation that many have been talking about, or the non-litigation situation that DeCarroll was talking about, and more information on the ability, the lack of or absence of lack of ability to get a lawyer, and have this information framed that is directed at the right issue, not the issue of just what harm do they cause.
Can we please see if we could get some articles or an article on the lay representation? And if Ms. Davis could come back, because I wanted to ask her some additional information.
So it sounds like we'll invite, go ahead, Judge.
Also wondering if the accommodations issue is something people are ready to vote on, as opposed to the workplace grievance issue, if we should just push everything and have some more information.
Leah, I would like you, if we're going to do more research, I would like you to send us the particular passages of the Justice Gap study addressing the question I asked last time, which is the person trying to find an attorney in these areas and not being able to.
Okay. So Judge Yu, I think because it's 1:22, let's push any voting to the next meeting. It sounds like we're going to invite DeCarroll. Hopefully you'll be able to come. We'll send you that information. Carolyn, it sounds like there's a couple more people you would like to have speak. Ira, I think the way you framed the question is great. I'm not sure there's universal consensus that that is the right question, but I think we're clear, and you certainly can ask the questions that way. We'll get any studies we can find on the impact of lay representation. additional information on the Justice Gap study. You have asked for that before, Stephen. And the Carolyn's request also about the upper income data. Okay.
Hey.
Thank you. And I think we will try to make the next meeting an hour and a half the way that we did with, I forgot which of our working groups we extended to an hour and a half. There's so many of them going on. We'll do that, and hopefully that will work with folks' schedules, because an hour is just too tight for all of this.
The evening will be better to take a little more time.
Okay.
Yes, so it's on the 11th at 5 o'clock. So you're saying it will go to 6:30 then?
We'll change the notice to 6:30.
Okay.
All right. Thank you all very much.
Everybody.
Bye.
Thank you.